Get ready, guys, for dictation of 1200 plus words at 120 plus speed. Start. At the request of learned counsel for the parties, the petition is taken up for final disposal. Stop. The public interest petition had to be filed in view of the internal disputes between the Postal Department and the government of National Capital Territory of Delhi, which has resulted in revenue stamps disappearing from the market. Stop. In terms of the impugned order, the Department of Ports withdrew the facility of sale of revenue stamps through post office due to non-receipt of commission on account of sale revenue stamps from Delhi Treasury. Stop. Thus, no stamps are available, causing grave inconvenience to public at large. Stop. It has to be appreciated that revenue stamps have to be affixed for the receipts and other purposes, and commercial transactions are being affected on account of non-availability of revenue stamps. Stop. Para. Learned counsel for the respondents state that a fresh order has now been issued whereby the Department of Ports has allowed restoration of the facility of sale of revenue stamps through post offices till further orders after getting the assurance from the government of Delhi. Stop. However, the latter is not clear as to till what period of time this arrangement would continue. Stop. In our considered view, the public at large must be assured that revenue stamps would be available from post offices as well, and if there are any disputes about payments to be settled between the Department of Ports and Government of Delhi, that may be mutually settled without causing inconvenience to the public. Stop. The department ought to have taken due care to settle the matter, and in a situation ought not to have risen resulting in the issuance of the impugned order. Stop. Para. In view of the aforesaid, we direct that the respondent shall ensure the availability of revenue stamps through post offices even in future, and it will not be permissible to stop the availability of revenue stamps in case of non-settlement of any financial dispute between the government of Delhi and the Department of Ports, for which the respondents can take recourses to appreciate proceedings between themselves. Stop. The writ petition and the application is disposed of on the revenue stamp aforesaid terms, leaving the parties to bear their own costs. Stop. Liberty is also granted to receive the petition in case of any difficulty. Stop. Para. This petition is filed by the petitioners aggrieved by order of Metropolitan Magistrate. In terms thereof, summons have been issued. Stop. It appears that the applicants, apprehending that they are likely to be arrested, approached the court by way of anticipatory bail, a copy of which is placed on record. Stop. The additional session judge, hearing the application without examining the true effects of the order made by the Metropolitan Magistrate, dismissed the application. Stop. It may be noted that learned additional session judge has mentioned in order that the accused persons have been summoned by the court of London Metropolitan Magistrate. Stop. Despite these facts, which were brought to the notice of the learned additional sessions judge, instead of directing the applicants to appear before the learned Metropolitan Magistrate in response to the summons, he dismissed application inter alia, stating that he was not inclined to grant the privilege of pre-arrest bail to the applicants. Stop. This situation was not warranted at all. Stop. Section 204 of the Criminal Procedure Code is required to be perused. Stop. Para. It is clear from the reading of the aforesaid section that it stop. Its summon is issued, it is only for the purpose of appearance of the accused before the court on the time and date indicated stop. Once the summons are issued, there is no question of apprehension of arrest stop. Para, there is no doubt that Code of Criminal Procedure in form of various sections from various chapters thought of providing expeditious remedy, which is very basic principle to criminal justice system, but too much of idealistic hangover and the so-called noble perception that our police machinery will be objective and efficient while handling a case has taken us in the country where the basic principle of criminal justice has ended into disaster and the notion of expeditious remedy has taken the backseat stop. Section 50 of the code, which casts the obligation on the police that in case of arrest without warrant of arrestee should be informed on the grounds of arrest as well as whether right to bail exists in that matter or not, so as to avail the remedy, but this procedure is hardly followed by police personnel stops. Moreover, the judgments like Vimal Kumar Sharma versus State of UP in fact spot of approach of police officers and provide them a way out to right granted under Article 22 of Indian Constitution by saying that ground of arrest need not set immediately but as soon as possible, hence providing a space where the officials can apply their whims and fancies stop. Section 57 of the code casts an obligation on the police to seize the person arrested before magistrate within 24 hours, but there exist serious doubts when cases like Manoj Kumar Agarwal versus State of UP are reported in which High Court held that not production within 24 hours will not make the arrest illegal. So in a way High Court even accepts the reality stop. Section 157, which provides for procedure for investigate, gives the IO an unfettered power in matter of conceivable offence because arrest has been made discretionary under this section and worries of the Supreme Court in the case of Joginder Kumar and hence giving a direction to the government to issue instructions to the department stop. Section 167 of the code provides for the procedure when investigation cannot be completed within 24 hours stop. Although under subsection 2 of section 167, the period within which the investigation needs to be completed is 60 or 90 days depending upon the nature of punishment, but our reports are full of such discretion distinction decisions in which the investigations has not been completed within the stipulated period of time and courts dare to state that if investigation is not completed within stipulated period then detention will not become illegal and the bail will be given only when the accused is ready to furnish the bail bond stop. The logic behind not giving suo motu bail in above mentioned case need to be relooked stop. The question why a person should suffer the investigating agency is not able to wind up its investigation within 2 or 3 months needs to be answered because after all unless proved guilty the accused will not be called guilty in the eyes of law stop. Subsection 5 makes it more horrible when it gives chance to agency to satisfy the magistrate the reason of not completing the investigation within 6 months stop. Para even a bail petition is filed before the court. A peculiar procedure is followed in courts, especially in lower courts, that is, without the submissions of case diary, the hearing on the petition will not start. That is, 3/4 chances are given to the office of public prosecutor to send the requisition slip demanding the diary to the procedure before the court stop. This giving of 3/4 chances mean that accused will have to be in jail for some days and hence he will have to suffer the mentally agony although he has not yet been declared guilty in the eyes of law. Stop.